not particularly clear. I did email the two lead regulators in Australia a week ago, knowing that I was coming here to give me an update. Unfortunately, I haven't had a response from them, but I may supply it in written evidence later on when I get it. I know both the regulators.
I think that would be very useful, because what we haven't yet had is anything upon which to base our deliberations upon in respect of this particularly difficult area. So that would be handy. On international comparisons, Professor, are there any other countries, legislatures, that have this kind of test other than Australia?
Well, not many other countries have gone for multidisciplinary partnerships or external ownership of investment and law firms, so the answer to that is no. The Americans, who you might have thought of would go in this area, have been hitherto fairly resistant, although there are one or two weakenings. But they do, for a few years, the Enron scandal because the big drive in the States towards MDPs and multidisciplinary partnerships came from the accountants. And Enron put a stop to that for several years. But
I can understand why. Thank you, Professor.
Robert Brown then, Stuart.
If I may, what about the position in European countries in particular, which one might think is one of the markets we might be interested in? Are there multidisciplinary partnerships in France or Germany or Italy, for example?
There are, in one or two instances, where tax accountants and lawyers can form partnerships in certain of the European countries, but the tax accountant is a very specialised type of professional, so it's not like, it doesn't mean you can have management consultants or accountants in partnership with lawyers. It's very self-contained, and it has not proved to be a problem, by the way.
Stuart Maxwell.
Thank you, Fiona. I just wanted to take you back, Professor Paterson, to Bill Butler's questioning on the risk of criminal elements from investing in or taking control of law firms. I think we can all see how it could be done. It's been done with other firms and other businesses. And the person who seems to own doesn't necessarily control the business. So I can understand how it could happen. But do you think there's in practical terms, in real terms, is there a genuine risk of these sort of elements taking control of law firms? I mean, why would they? I mean, they could employ a lawyer just as easily, if not easier, than taking control of a firm.
Yes, take that point.
Yeah. Okay.
Okay, you've anticipated some of the questions that James Kelly was anticipating asking. Is there anything you wish to follow up?
Just on the issue of regulation, clearly, as has been spoken about throughout the evidence sessions, the regulation being proposed is complex, and one of the concerns that's been raised is the budget allocated in order to oversee this is perhaps minimal. I think it's a starting figure of around £13,000. I just wondered if you had any views on that and whether enough finance has been put forward in terms of supporting the new regulatory system.
I mean, this is government finance, is it?
Yes.
Sounds a bit on the low side. The government ministers will perform the role of the Legal Services Board down south. I think they may find it costs them rather more than that. The Legal Services Board is a very lean outfit and was designed in that way and has a relatively small staff, 35. But I think the government might find that they're having to spend a little more than that.
Thank you, Convener. Just following on from the issue about ministers' involvement, not so much the budgetary involvement, but there have been arguments and evidence suggesting that effectively there's a problem with the bill creating ministers in the regulatory role, the oversee role, and the independence of the legal profession. Do you share that concern, and if so, why?
I see where it's coming from, but I think that the fact that they're going to be subject to the better regulation principles and subject to scrutiny doesn't give me great concerns. I think I can see where the concern's coming from, but then, you know, I think external ownership and multidisciplinary partnerships worry me about the threat to the independence of the profession as well. So these are all threats that come with it. I think, presumably, the government is open to judicial review for anything it does in this area. So I think that, too, is a further protection. I've said in my evidence I wouldn't necessarily be opposed to the Lord President playing a role, but I think it would have to be a fairly confined role to areas of legal competence and so on.
Having said that, do you think there are further safeguards required that are not currently in the bill? Are there other things that should be put in place to ensure that independence, or do you think the bill strikes the balance as best as it can? On independence from the government, I can see there's an argument, and therefore I'm prepared. You know, I can see an argument for bringing in the Lord President in the kind of way we've discussed earlier, but it's kind of awkward. I mean, who's deciding on an application? Is it the Minister? Or is it the Lord President? Does the Lord President have a veto? Is it something they do jointly? I'm not sure I quite see the argument. I actually do wonder whether, in the end of the day, we're not going to be forced into having a legal services board, which, again, you might say is very bureaucratic. But it's a super regulator, and the point is the way you set up the legal services board in England and Wales guarantees the independence. That's the way that they get around that problem there. Would that be proportionate for Scotland, though, having such a board?
That's the debate. The ministers think not.
Well, what do you think?
Depends how it's done, frankly. I can see the argument, and I think it's finely balanced, and I'm not necessarily in favour of more bureaucracy just for the sake of it. But I could see certain advantages in having an independent legal services board.
Okay, thank you.
Cathy Craigie.
Professor Paterson, we have some written evidence from a whole host of interested individuals representing different parts of the Scottish legal profession. One of the submissions that we have suggests that if the bill is passed in its present form, the independent Scottish legal profession, as we know it, will be in danger of being lost forever. And indeed it goes on to say that once this process begins, there is a danger that the practice of Scots law will reduce. The suggestion there that firms would move south and implement their practices. Do you have any comment on that?
Yes, I saw that. I was intrigued because I think one of the arguments that the large law firms might have used, if they used arguments, on this matter, was that the threat that they might move south. Because much of what large law firms in Scotland do is not within the reserved areas. In other words, you don't need to be a Scottish solicitor to do it. So they could have moved south and re-registered as an alternative business structure in England and Wales. Now, that would have had, I think, quite serious impacts on the provision of legal services in Scotland, the separate legal system in Scotland, the legal culture, and so on. Fortunately, I think they do value being Scottish solicitors, whether it's the brand or the independents, but I think that our large law firms, most of them, do value the brand of being Scottish solicitors. So I think it's less likely that if we have alternative business structures that they'll move south. I think it's more likely that if we didn't have it, that they might move south. Or at least register down south.
Thank you very much. I just wanted to revert to the issue of the execution